Good afternoon, everybody. I don't know what I'm going to do after that last presentation. I'll try my best to talk about a hard act to follow. And also, I'm quite scared of Ursula, so I'll try and stick to the 30 minutes. She looks quite scary, and I don't get any of those notes. You have a document in your folder, which is an Employment Law Association application form. And it's Maria, who the next speaker is a committee member, and the Employment Law Association is an association of solicitors, barristers, HR, people who practice in employment law, and it's an excellent organisation to join. €85, not a huge amount of money, and the benefit is even if you can't travel to the excellent papers that they have and seminars, you can access them from the website. And it's a really good organisation in terms of networking, and obviously Maria, who's speaking next, is a committee member, so all questions directed to Maria. I've just done what I was told. Okay, so what I'm going to talk about is I'm going to talk about age discrimination in employment law. And what I'm going to look at is mandatory retirement ages, really, because that is the kind of the issue for older employees. In other words, do I have to retire? Can my employer force me to retire? And then for an employer's perspective, do I have to retire this employee? Because the reality is, does anyone know how the age of 65 was set as a retirement age? Does anyone know when it was done? Yes?
Apparently based on the retirement age of the state pension.
No, but do you know when the age of 65, when it was developed? Or Bismarck, exactly. 65 was developed by Bismarck in Weimar, Germany, when the average life expectancy was 68. So obviously you were expected to retire at 65 and basically croak it within a couple of years afterwards. Now, that's obviously changed significantly since, and people are living longer, people are healthier. The average life expectancy is 82 for women, of course, and 78 for men. So men and women want to work longer. Obviously, we're all aware of the fact that the pension crisis has caused, employers are either no longer giving pensions, or if they are, they're defined contribution pensions. And in a lot of cases, employees are being expected to provide their own pension situation. So, and a lot of people are relying on the state pension. And as you know, the state pension age has now changed from 65 to 66. It's going to change to 67 in 2021. So we'll all probably be working till we're 80, some of us who are in our 30s, and 68 in 2028. So what that means is employees who are being forced to retire at 65 are not going to get the state pension for potentially a number of years within their pension, which is generally, that's what's in a number of pension schemes, it will kick in when the state pension kicks in. So what do employees do? They look to stay on with their employment, and I'll look at that, or else they go on job seekers for 9 months, and that it then becomes means tested, and they can be stuck in very, very vulnerable financial situations. So I suppose I see in the future, which is good for all lawyers, that there'll be a lot of litigation in this area, because employees, the only people who benefit out of litigation, I was just saying this to Mary earlier, are lawyers, really, to be perfectly honest. But in litigation, employees will take cases because they will be left with no option but to take cases. And from an employer's perspective, employers may want to keep on. I'm seeing it increasingly. I do a lot of advisory work as well. But employers will say, look, I want to keep Mary on. She's doing a great job. She's 65. She's very fit. She has a huge amount of experience, which I'm not going to be able to get in the market. I want to keep her on. But I don't want to jeopardise potentially retirement age. So that's when the advisory work kicks in. And I'll deal with that. And the other option is that employers now, because as a matter of law, employers have to objectively justify retirement ages, they're effectively trying to do so retrospectively, because they never expected, when they took on Mary Bloggs 30 years ago, that they would be required to then justify retiring Mary Bloggs at 65. And in a lot of cases, a lot of employers now are only hitting the retirement age and the potential challenge to retirement ages at this stage. So it's a very problematic area, but for lawyers, lots of work, which is great, and we like that. So a lot of cases coming before about the Equality Tribunal and the Labour Court, and I suppose at this stage, the benefit to equality legislation under the Employment Equality Acts, unlike, for example, the Unfair Dismissals Act, is that there's mandatory mediation. Well, there's a mandatory option of mediation in employment equality. Now that will all change because there's a huge change to the employment structures, and there will be an option now for early conciliation and mediation. So if an employee brings a claim under the Employment Equality Acts, they will be offered mediation, and it's free, and they're by trained mediators, normally you have to pay mediators. So that is hugely beneficial. situations. And I would always encourage parties to mediate if I can, if they will. And particularly, say for example, in the context maybe of age discrimination, when the employee still remains in employment, mediation is very, very valuable. So that is just something to bear in mind. Okay, so in relation to establishing a retirement age, how does an employer establish a retirement age? Because guess what, a lot of employers still don't provide written documentation or written contracts of employment. So there's three ways of establishing a retirement age. Generally in the contract of employment, it will require, it'll have a retirement age. Custom and practice, in other words, all employees have retired at the age of 65 when they reach it, without any exception generally, or else implied from the pension. And the decision of Malloy and Connacht Gold is a good example. In this case, the employer did not have any written contract setting out a retirement age, but every employee had retired at 65. There have been one or two general exceptions to that, but very much on an exceptional basis. And on that basis, it was held to apply. And the High Court in McCarthy and HSE implied a retirement age on the basis of pension documentation. In other words, the HSE didn't have it in their contract. This lady had been there for a long time and didn't receive a contract at the time. And therefore, because she was getting a pension at the age of 65 and all employees within the HSE had been terminated at 65, A, it was custom and practice, and B, the judge said that she should have known that she was going to be expected to retire at 65. By contrast, if there's no retirement age in place and it's not established, and this is happening, I'm seeing this across the board, where employers are facing it for the first time. So they don't have any written retirement age and they're facing retirement of employees for the first time. In this case of O'Neill and Fairview Motors is an extremely good example. And in this case, this guy was a mechanic, exceptionally good employee, no issues with his performance, reached 65, actually I think it might have been 66, and they retired him. And he had worked on his own in the workshop, so there was no issue with his performance or any health and safety issues. And the employer tried to say, well, retirement age, you should have known about it. We didn't, it's established by way of customer practice across the motor industry that all mechanics retire at 65, 66, but produced no evidence. So completely nebulous. And the Equality Tribunal said they could not rely on the retirement age because it just simply wasn't established. And then also there was no reason to retire him, and we'll look at this later on, but he was an exemplary employee, he was still working at a high level, no health and safety concerns whatsoever. He had no performance issues, and simply to retire him was discriminatory in breach of the Employment Equality Act, and he received a relatively high level of compensation. So that is a good example. Custom and practice, I think it's difficult for employers to rely on custom and practice across an industry. There is a decision of the High Court, I'm trying to remember the name of it, where the President of the High Court held that non-payments during periods of layoff could be established across the construction industry because it was across the board that no employees received pay during layoff. So potentially it's an option there, but I think you would have to have an extremely well-established practice across a particular industry for an employer to rely on it by way of customer practice. But potentially, and it depends on the High Court judge, I suppose, who you draw. Now, there's the option of challenging any termination of employment when you reach retirement age, either under the Unfair Dismissals Act or under the Employment Equality Acts. And generally, most of them would be challenged under the Employment Equality Acts, but they do happen under the Unfair Dismissals Act as well. However, the Unfair Dismissals Act is not as broad as the Employment Equality Acts, because if an employer can show that they have a normal retirement age in place and the employee retired when they reached the normal retirement age, their employment is terminated, that was the reason for the termination of employment, that's the end of the case. It's a full defence to an employer. However, employment equality is very different, because not only does the employer have to show they can establish a retirement age, they have to objectively justify it. So it's an additional layer for the employer to meet. So therefore, it's much more onerous under the Employment Equality Acts, which I suspect is why most of the cases are coming under the Employment Equality Acts as opposed to the Unfair Dismissals Acts. So in terms of establishing a normal retirement age, what the Employment Appeals Tribunal will do is, under the Unfair Dismissals Act, they will look at, is there a normal retirement age? Is it in writing? Has it been applied? Because it's all very well and good having a retirement age of 65, but your 20 employees in the last year were kept on and they're now 70. I actually did a case for a 92-year-old there a few years ago who was still working. So some employers ignore retirement ages. But it's all very well and good having it in writing, but it has to be applied across the board. And if there's any exceptions, they have to be very narrow. And I'll look at that going forward. Okay. So, age discrimination. So under the Employment Equality Act, as I've said, there's 9 grounds, and I'm not going to try and name all 9 because I always forget 1 or 2 of some of the 9. Then I look quite embarrassed. But so age is one of the grounds, and mandatory retirement ages is the big area of age discrimination. There's also been age discrimination in the context of recruitment. So some employers may simply not recruit employees who are aged 50. Rather, I heard this recently, doesn't really augur well for anybody. Apparently when you get to 40 and you're unemployed, you have more difficulty getting a job than when you're in your 30s, and you've got a much lower chance of getting any work. So anyway, I don't like to hear stories like that, but in any event, some employers will not want to employ older employees. And there's a very low level of, particularly when employees get to 50 or 55, it's extremely difficult for employees to get alternative work if their employment is terminated. But employers need to be very careful in why they do not employ older employees, and they need to be fair and transparent in the application process, because the hugely radical issue with the Employment Equality Act is it applies before employment, so it applies during a recruitment process, interview, all the way right through to dismissal, and even post-dismissal in certain circumstances. So it's a hugely radical piece of legislation. If, for example, I feel I was discriminated in the workplace, I was dismissed because I'm old, and then I was refused a reference. So after the termination of my employment, I may still have a claim both of discriminatory dismissal under the Employment Equality Act, but also victimisation. In other words, I was victimised because I brought a claim. So hugely significant piece of legislation. Okay, so in the context of mandatory retirement ages, so what an employer is trying to do in the context of retirement ages is to allow younger employees to move up through the workforce, but also to retain key employees. Because employers, to be perfectly honest, don't really care who's working for them once they're experienced and once they do a good job in a lot of cases. So, but they will generally want to have some type of level of proper planning to allow younger employees know when there's promotional prospects, but also to create a situation where they can get the maximum competitive benefit in the market. So, Section 34 of the Employment Equality Act provides that the fixing of retirement ages is perfectly lawful. It's very blunt, but that is not the end of the matter, because Article 6 of the Framework Directive, the Framework Employment Directive, which has been interpreted harmoniously by the Equality Tribunal and the Labour Court, says it has to be objectively justified. And that's where it kicks in. So you have to, if you fix a mandatory retirement age, the employer has to show that this mandatory retirement age is objectively and reasonably justified, and that the means of retiring the person by way of reaching 65 is appropriate and necessary, and that's what I'm going to look at. In other words, objective justification. Is this a proportionate response to the meeting of somebody reaching the age of 65? So, for example, an employer could see that an employee has reached the age of 65, but could put them on fixed-term contracts, for example, potentially an option, or could have them medically assessed on a year-to-year basis. If they don't consider those options, the termination of employment could be disproportionate, potentially. The decision of Palacios, which is a Spanish case. In that case, in Spain, they had a retirement age of 65 because it was extremely difficult economic times in Spain. And essentially what they were saying is we need younger people to come into the labour market. There's no jobs because we're in a very serious economic recession. And if we don't have this retirement age in place, there will be no promotion and there will be no access to employment for employees within Spain. And that was held to be objectively justified. So, in other words, the labour market policy within Spain, due to the difficult economic circumstances, was found to constitute objective justification. So again, showing a very exceptional basis. In other words, perhaps if the economic circumstances had not been so serious in Spain, and there was no issues with younger people getting into the labour market, it may potentially not have been found to be objectively justified by the court. The decision of Donlan is an interesting case. Martin Donlan was the Assistant Garda Commissioner here, and he challenged the age of retirement of 60. And what he said is, I don't want to retire at 60. I'm well able to continue in my post, and it constitutes discrimination. And the High Court said, yes, potentially it could constitute discrimination on grounds of age. You're being forced to retire at 60. But in the circumstances of the case, they found it was objectively justified. And there was extensive evidence given in the High Court that if there was no retirement age of 60 within the Gardaí, there would have been no promotions to senior positions within the Guards for a period of 15 years. So it would have been effectively stymieing the younger individuals to move up through the ranks in terms of promotion. And the other matter, they said that the guards had a peculiar structure, which I think we all know is the case with the guards, and also to ensure motivation for younger members of staff. So in other words, younger members of guards are entitled to know that I have a prospect of being promoted if I continue as I am. And in other words, there's a retirement age of 60. And significantly in this case, the guards, there was an application process. Martin Donlan had actually applied to stay on as Assistant Garda Commissioner. So there's a prospect of having that considered on a case-by-case basis, but he had been turned down, and that was found to be lawful. So it's a very good example. I'd hate to think how much his legal costs were, because the judgment is 250 pages long, so I suspect it was a long case in the High Court. Now, Doyle and ESBI is a case obviously involving ESB. ESBI is ESB International, which is a more corporate end of ESB, so not as civil service in mentality as ESB. But in this case, there was an established age of 65. All employees were required to retire at 65, although there was nothing in writing to that effect. And what the equality officer held in that case was that capping it at 65 had been carefully considered by ESB. ESB had sat down, had looked at what age should we make retirement, and they carefully considered the promotional prospects of younger employees, the fact that they wanted one retirement age across the board. In other words, they didn't want 55 for one level, say for engineers, 70 for, say, executive officers. They wanted a standard age so that everybody across the board would know that 65 was the retirement age. And they also looked at the fact that it would encourage younger individuals to be promoted, and also recruitment of younger individuals. Good personnel management. In other words, if an employee, and I actually had this in a case where an employee had stayed in employment and she was 75 at this stage, and the employer just knew she wasn't unfortunately fit to continue in employment but didn't want to say it to her, so kind of just dismissed her on the spot. There is an issue with good personnel management. In other words, an employer may not want to necessarily performance manage an employee because their performance is unfortunately diminishing by virtue of their getting older, and so therefore that it can be an important consideration. So that was upheld. The recent decision of Roche is significant. I've looked at it in the paper. There's a detailed paper which you will get a copy of. The significance of that case is that they could show the employer, it's a private sector employer, which is significant because most of the cases are concerned with the public sector, when obviously it's much easier to establish a good, generally intergenerational mix. In other words, younger and older employers and employees in the public sector. But in this case, this guy was involved in a very, very technical job, and he was retired. And because a layperson off the street just couldn't take over his job, somebody internally had to be promoted up to take over the job, and that's why in that case it was found to be objectively justified. Significantly also, he was getting a pension, and also he was offered a fixed term contract for a short period of time which he turned down. So it's showing that what the equality officers and the Labour Court are saying is, yes, retirement ages can be upheld, but you should look at potentially allowing older employees to remain in employment on a fixed term basis, and also if they have a pension, that goes some way to assist them when they are going to be unfortunately unemployed following the termination of their employment. If they don't have a pension, you can see the equality officers of the Labour Court being a bit more sympathetic towards the employees. Okay. So in terms of what has constituted objective justification within the meaning of the Act, they've looked at what the case law shows both from the Court of Justice, the Equality Tribunal and the Labour Court is public interest, social, budgetary aims or demographic concerns. So in terms of physical demands, it's very obvious. A lot of employers will say, oh, well, sure, he's not up to it or she's not up to it. The reality is, unless the employee's job is particularly physically onerous, physical demands are not going to constitute objective justification. Most employees sit behind a desk, generally. So because they've reached 65, it doesn't mean that the physical demands of the job are to the extent that they should be retired. Firefighters are slightly different, and that's on the basis of medical evidence to show that as somebody gets older, they're not able to physically undertake the tasks to the same extent. And there is a decision involving a winchman where 55 was upheld. But those are very exceptional cases. As I said, what's so-called intergenerational fairness has been established, retaining staff, in other words, allowing them to say, I have the prospect of promotion in a certain period of time, performance management process. And there's a decision involving solicitor's practice in the UK, and went all the way to the Supreme Court, and Baroness Hale, in her usual style, gave an absolutely phenomenally clear judgment. The absolute the huge benefit to the judgment is that there's a large amount of European Court of Justice cases, and she summarised them all and the principles in them. So you read it and you pick up very quickly as to what the situation is with the Court of Justice. Very, very good judgment. And that was in the context of the retirement of a salaried partner within a law firm. And she said very strongly that this could constitute objective justification because, again, promotional prospects for younger employees in certain cases. Protecting health and safety of employees. And I've told the story quite a few times, but having been in a taxi about 2 years ago where the driver was, I think, about 90, and I thought I was going to not get to where I was going, I can see sometimes that health and safety can be an issue in certain cases. I was very glad to get to where I was going to. Potentially, you can carry out medical assessment on employees on a year-to-year basis, and motivation is another situation. I'm going to look at the decision of Thomas O'Mahony, which is a recent decision, because it's a very good example of how an employer cannot simply seek to retrospectively put in place reasons which simply don't stack up on the evidence. This guy took up employment when he was 65, and he was driving, these locum doctors at the weekends, or your GP would send you there, and he's driving the doctors around. He started when he was 61, and there was an attempt to put in a retirement age of 65 into the contracts. He objected, and then when he got to 65, they tried to retire him. And he said, it's not, I'm perfectly capable of my job. I'm very, I have no performance issues. It's not a physically demanding job. All I do is drive a car and drive doctors around the place. And I want to stay in employment. And what they tried to argue was that, essentially, they wanted to try and promote younger employees. The problem was they had no younger employees in place. So it was a little bit of a difficult argument. There was no mix in the generations. So they weren't able to rely on that reason. And then they tried to rely on health and safety reasons, but they had no medical evidence or anything. I mean, driving a car, it doesn't mean that you're going to be a danger on the road just when you reach 65, generally. I think if you're a bad driver, you're a bad driver at any age. So they were not allowed to rely on it. So these reasons where there was no cogent evidence provided, and they just simply didn't stack up, and the equality officer saw it for what it was. It was an attempt to save money, not pay redundancy, and because they were in financial difficulties, and they just terminated him when he reached the age of 65. In reality, it was a redundancy situation. He wasn't replaced. So this intergenerational fairness, when he wasn't actually being replaced by anybody, it was effectively nonsensical. Okay, there is an option of keeping employees on fixed-term contracts, and that is lawful within the Employment Equality Acts. In my view, that is only to be used in exceptional circumstances. In other words, employers cannot simply say, okay, you've reached 65, I'm going to put you on fixed-term contracts and keep you on rolling fixed-term contracts. Essentially, employers generally should only look at this option if they want to extend an employee beyond the age of 65, if the employee has particular expertise which they simply cannot replace, which is quite common for employees when they've been in employment for a long period of time. Or if, for example, there's a short-term project that they need a particular employee for, but they cannot just simply use fixed-term contracts in a blunt manner because they have to, in my view, objectively justify it. And the Court of Justice have been very clear on this, in spite of what the Irish legislation says. Mangold was a German decision where after the age of 52, which is very young, particularly as I get a bit older, it's starting to seem quite young, 52 years of age across a certain sector of Germany, we're put on fixed-term contracts. So the Court of Justice said, but what are you doing? It doesn't make any sense. 52 is young. There's no reason why you're doing it. So they rejected that. There is a more recent decision, Georgiev, which is a decision, I think, from Romania or Bulgaria, involving university lecturers. And university lecturers in Romania, I think it's Romania actually, are put on fixed-term contracts when they reach 65, up to the age of 68. And the Court of Justice, and that is really to try and retain expertise for short-term periods. The Court of Justice said it potentially could be objectively justified, but they're quite clear from the judgment that in fact it wasn't even being applied. Some people were being kept on to 70, some people were being put on short fixed-term contracts, some professors were being simply dumped at 65, so it didn't seem to make any sense. I'd be interested to know what happened when the case went back. But in any event, that is a potential option for employers, but I would suggest only in exceptional circumstances. And if an employer is offering fixed-term contracts, it really can be on the basis of transparent criteria. And the HSE, yet again, they're a great fodder for work for employment lawyers. They fell foul of it because in a case called Fitzgerald and the HSE, they offered extensions to 2 men, but not to a woman. And they tried to say that, what they had, if they had sufficient numbers on particular panels, they wouldn't offer fixed-term contracts because there was no need for the employee to be put on fixed-term contracts. But one of the men was, just before he reached retirement age, was effectively side moved, and his title was changed, so it would look as if there was nobody on the panel for his position. So lack of transparency, which, as we know, can give rise to discrimination. So there was no transparent, clear policy that was being applied in a fair manner, and on that basis they fell foul. So if there are being offered, it has to be offered on clear, in my view, written criteria. And there is a recent decision involving, it's not NUI Galway, it's actually NUI Maynooth. So it's not NUIG for once. And in this case, this individual, she applied. She was an executive officer. She applied to stay on for after her retirement age, which is well established within NUI. She needed the money. Unsurprisingly, her pension just didn't simply provide the level of comfort that she had hoped. And when she applied, she wasn't retained because the employment control framework, as we're all familiar with, generally shows that they had to try and reduce numbers, headcount, by up between 2 and 6%. And essentially what that means is that employers within the public sector have to try and try and bring in employees from redeployment panels, or simply not replace them at all. And when she applied, there was no particular need for her to remain on. And there had been 4 employees in NUI kept on over a period of 10 years post the age of 65. All of them had very specific facts. One of them, funding would have been lost because she was a researcher if she'd been forced to retire, and the rest of them had particular expertise that simply could not be replaced. And on that basis, they found that the retirement age was objectively justified on the basis of the employment framework, the need to reduce staff, and also the fact that there's no need to keep her on because essentially her role could be undertaken by others. Now, there is a new bill. There's 2 private members' bills. We all know how successful private members' bills are. There's 2 private members' bills. One which is effectively, as I see it, just been suspended 2012 to abolish 65 as a retirement age except in limited circumstances. And the new bill from Anne Ferris, currently, to abolish the retirement age for those aged 65 for people who are willing and able to work. They're going to go absolutely nowhere. I can't imagine either of those are going to be passed. Now, just moving on briefly, indirect discrimination and race. And the reason I mention this is because there's a recent decision which has actually been referred from Ireland to the Court of Justice, literally on Monday by the Labour Court. And in this, indirect discrimination is a more subtle, institutionalised form of indirect discrimination, which I think NUI Galway might be familiar with from that recent Equality Tribunal decision. But in any event, it's institutionalised discrimination where a rule on its face appears to be neutral, but when you look behind it, it causes difficulties for a particular class. So, for example, age discrimination. If new criteria are brought in internally to increase, for example, qualifications. There's a case involving University of Kent where they introduced a requirement that senior lecturers had to have PhDs within a university. And as we all know, PhDs are obviously now becoming like masters. Everyone has them. Don't get me wrong, I would never, ever, I don't have one. I never will. But in any event, that causes, it looks to be neutral on its face, but it's causing difficulty for older employees because older employees simply do not have PhDs. So potentially that could constitute indirect discrimination on grounds of age. And I would have thought it's probably objectively justified because it seems to me to be reasonable for a university, well, let's not go, I'm not going to say anything else about that reason, for PhDs, for senior lecturers to have PhDs. Having regard to it being an objective, a reasonable requirement for the position, a genuine occupational requirement, so to speak. There's a decision of the Labour Court which was referred on Monday, and I tell you what, whoever came up with this combination deserves a gold medal, and I think I know who it was. It's always good to have barristers sometimes. But in this case, this guy was employed by Trinity. He was gay. He got civil partnered in, it's called Paris and Trinity. Got civil partnered in 2009. And then when the Act came in, he regularised his position. But because he was aged over 60, his partner was not recognised for pension purposes because Mr. Paris was aged over 60 at that stage. So he wasn't entitled to any of the benefits. His partner was not entitled to any of the benefits under the pension. And the Equality Tribunal held that the combination of age, sexual orientation and civil status all combined together, that rule constituted indirect discrimination. As I said, there's a combination. because basically he was being less favourably treated than a straight, younger man who would have been in a position to regularise his position earlier because he would have got married and would have been entitled to have his partner admitted into the pension. That has been referred by the Labour Court to the Court of Justice as of Monday of this week, very much on the basis of age discrimination, because what the Equality Officer said was, I have sympathy for you, I think it's indirect discrimination, but I can't do anything because we've got the 2012 Act, what can I do? In spite of the fact, in my view, ignoring the fact that sexual orientation is a ground under the Irish legislation and the Framework Directive. I'm not going to run foul of Ursula. Thank you very much.